Hearing in the appeal RR against Secretary of State for Work and Pensions.
Yes, but Mr. Drabble, it says on our front sheet, so to speak, that the court is expected to make a reporting restrictions order.
Yes.
But we would like to have it explained to us what the legal basis for such an order is in this case.
Yeah, well, your ladyship should know that this matter was addressed in front of the upper tribunal, and at MS 336. I can find my way.
336.
Doing very well.
There's a decision of the upper tribunal.
Yes, it's a single sentence at MS 336. I'm catching up with myself and getting to.
The claimant will not be identifiable in any public version of the eventual decision, any post-decision determinations.
That's it. That was written in a response to a letter from Lee Day, which is not in the papers, dated the 15th of June, which states, we seek the tribunal's agreement to anonymise the case as per section 14(1)(a) of the upper tribunal procedure rules. Respondent's wife is very unwell. She returned yesterday for an inpatient admission in hospital.
I'm sorry, I can't hear you, Mr.
Sorry, my fault. The respondent's wife is very unwell. She returned yesterday from an inpatient admission to hospital, and the couple are under a significant amount of stress. In addition, a number of years ago, the couple were involved in a distressing incident about which the press became aware and consequently attempted to contact the couple and visit the house. And on the basis of the medical vulnerability, which is disclosed obviously on the underlying facts of the case, and the contents of the letter which I have just read, that the application for anonymity was granted in the terms that you've just seen, by the upper tribunal. Court.
Yes, and was in the court below as well. And there's no objection from the respondent. So,
Yes.
Well, we'll make the order, but we're grateful for the explanation because
Yes.
we are always conscious that there are limits to our powers to anonymise proceedings, and we wish to exercise them responsibly and not just on the nod. So the order is that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which will be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings. I always say this at the outset of our proceedings because, as you are all aware, they are broadcast live on the internet, and indeed they are archived so that anybody can look at them since. So care has to be taken. I know you know that, Mr. Drabble.
I know because I found out rather sharply on one fairly recent occasion, as your ladyship knows.
Yes.
I shall
Very
bear it in mind.
That out of the way.
That out of the way. I was slightly forewarned that will be the first question. May it please the court, I appear for the appellant, RR, together with my learned friend Matthew Fraser. My learned friends Sir James Eadie, Queen's Counsel, and Edward Brown appear for the respondent, Secretary of State. My learned friends Dan Squires, QC, and Chris Butler appear for the Equality and Human Rights Commission. Martin Chamberlain, Queen's Counsel, Tom Royston, and Jennifer MacLeod appear for the group of second interveners, Liberty Child Poverty Action Group and the Public Law Project. I should say, and it will point us a little significance in this case, that Sefton Borough Council, who are the actual decision makers in the case, do not appear and have indicated no desire to take part in the proceedings or to take any future steps in relation to the payment of housing benefit or whatever has taken place. Housekeeping other than the anonymity order, we have handed up 4 pieces of paper. I don't know whether the court, my ladies and my lord, have got them clipped together. Can I just identify them? They're filling in gaps in the documentation that is in front of the court. I don't think there's any need, there may never be any need, to engage with the detail of them. The first is called the appellant's note on regulation B13, which is the regulation that requires the deduction in relation to the size criteria. We've tried to find a way of guiding any member of the court who wants to understand the evolution in detail through the material in front of the court. If you want to get to grips with all the definition sections and so on, it is a bit of a wet towel job. There may not be any need to do it, but I think the note will do its job if you sit down in that way and do it. I'll try my best to get to the crucial bits anyway.
Well, yes.
The second piece of paper is B13 in its very original form, the full version in force on the 1st of April 2013. The next piece of paper are extracts from the Social Security Contribution and Benefits Act 1992 relating to the statutory provisions dealing with the disability living allowance, sections 71 and 72. They're important because in the evolution of B13, they became used as the definition of people who are sufficiently disabled to bring into play the principle of interpretation established first of all by Burnip and Gorrie and then by Carmichael. And then finally, there's the empowering provision for B13,
Yes.
which is section 130 of the Social Security Contribution and Benefits Act 1992, provides for entitlement to housing benefit. A person is entitled to housing benefit if A, he's liable to make payments in respect of dwelling in Great Britain which he occupies as his home, and then if very foot of the page, where a person is entitled to housing benefit, then A, if he has no income or his income does not exceed the applicable amount, the amount of the housing benefit should be the amount which is the appropriate maximum housing benefit in his case, and then B provides in essence for a taper. So if you have no other income, you get the maximum housing benefit, and B13 is a regulation providing for one of the steps in establishing what is the maximum housing benefit. That structure may be important to the second issue when we get to it. Now, my ladies and my lords will have seen that this is my appeal from a decision of Upper Tribunal Judge Lloyd Davis, who allowed the Secretary of State's appeal against the decision of the First Tier Tribunal, awarding my client housing benefit at the full rate for his rented property, unaffected by any deduction under the housing benefit regulations in respect of under occupation. I'll come back to a bit more detail of those in a moment. The appeal to this court is made following the grant of a leapfrog certificate by the judge, who was compelled to allow the Secretary of State's appeal because of the reasoning of the majority of the Court of Appeal in Carmichael. The appeal is expedited because determination of the issues involved in the 2 grounds of appeal are necessary to enable the upper tribunal to deal with cases stay before it. And if your lordships and my ladies glance at MS 164 in the core volume, paragraph 5, in paragraph 5 at MS 164, Judge Lloyd Davis states, in the final paragraph of their application for a certificate, RR and DL request the tribunal to give an indication of the current backlog of similar cases in order to support their application, potential requests for expedition. In terms of numbers, there are currently about 140 like English and Welsh cases stayed in London, and about 25 like Scottish cases assisted in Edinburgh, and then states the dates that they were received, and so on. So those are the cases in front of the upper tribunal which are staying pending, yes?
Well, we understand that there was a good reason to get on with it.
Yes. The subsidiary point about that is that we can document this if it's necessary, included in that group of cases and the other cases that are stayed in front of the first tier tribunal, numbers unknown, are cases where there will have been payment of DHPs for the whole period, DHPs for part of the period, and no DHPs at all. They're all in the mix, and accordingly, hence the need to answer the two issues.
Well, the second one appears, to some of us at least, to be the more difficult of the two issues that you have to confront. Yes, well, let me deal with that in my own way. You deal with it in your own way.
I'm not 100% surprised by that, but we'll come, our submission, obviously, at the end of the day, is that the order made by the upper tribunal is precisely the correct order to be once you've understood the decision-making structure that's in play here. It's answered the statutory question which was before it on the appeal, and other issues relating to payment of benefit or recovery of allegedly overpaid DHPs were simply not in front of the original decision maker, who was Sefton, in April 2013, before any issue of DHPs arose at all, or the FTT. No submission made to the FTT, or couldn't have been made, about payment of housing benefit, because payment of housing benefit is not for the FTT. And similarly, by parity of reasoning, was not in front of the upper tribunal or the Court of Appeal, who is exercising the same statutory powers. So that's the submission. I mean, that is the shape of the answer to the second question. We'll come back to a bit more detail of that in due course. So I anticipate I still have to deal with issue one.
You do?
Yeah, well, of course. Now, in order to explain the context of the two issues, which the Court's obviously familiar with, we need to take the Court to three sets of statutory provisions, hopefully fairly shortly, but they interlock in this case. The first set of statutory provisions are those relating to the size criteria in the housing benefit regulation. The drafting, as the upper tribunal in the Carmichael case commented, is complicated. Typical Social Security drafting, the upper tribunal comment on it, I make no comment. But the underlying structure is fairly straightforward, and it's the underlying structure which, on our case, matters. The second set of provisions are those for which the Court will be very familiar, but contained in the Human Rights Act, and in particular it's necessary to consider the relationship between sections 3, 6 and 8. And thirdly, those relating to the decision-making structure in play where a claim for housing benefit is made. Amongst other things, for the submission that we make on the second issue. So the size criteria. The starting place is obviously the empowering provision, section 130, and that's in the clip, I've just shown the Court the principal characteristics of section 130. But if the Court looks at section 133A, the basic provision is that where a person is entitled to housing benefit, then A, if he has no income or his income does not exceed the applicable amount, the amount of his housing benefit shall be the amount which is the appropriate maximum housing benefit in his case. So what we're looking for is the identification of the maximum housing benefit. Section states read as a whole, 131 together with 3, that there is an entitlement to that maximum amount. We say that was the statutory question in front of Sefton in April 2013, 2014. In April 2013, and the statutory question which was in front, therefore, the FTT and the upper tribunal. Now, the simplest way, tried to find a way of dealing with this without getting really bogged down in the detail. Simplest way of explaining the way the size criteria work is to take the court to MS 203, where we are in the Carmichael Upper Tribunal decision. And halfway down MS 203, Carmichael Upper Tribunal inserted a heading saying the social housing size criteria in the housing benefit scheme. I don't think I need read 8. 9 says, so far as primary legislation is concerned, section 130 subsection 1 of the Social Security of the 92 Act provided that a person is entitled to housing benefit if certain conditions are satisfied. One of those requirements is there's an appropriate maximum housing benefit in his or her case. The appropriate maximum housing benefit is determined in accordance with regulations. In any given case, an individual's maximum housing benefit is calculated in accordance with Part 8. For present purposes, the starting point in the secondary legislation is Regulation 11.1, which provides that housing benefit shall be payable in respect of rent and related payments, and that a claimant's maximum housing benefit shall be calculated by reference to the amount of his eligible rent, determined in accordance with whichever further regulation is applicable in his or her case. The concept of eligible rent is then defined by Regulation 12B, unless one of a number of other provisions applies. One such exceptional case is Regulation 12BA, which applies in turn where a maximum rent social sector has been or is to be determined in accordance with Regulation A13, where a maximum rent social sector is to be determined, Regulation 12BA1. In such a case, subject to various immaterial exceptions, the amount of a person's eligible rent is the maximum rent social sector, Regulation 12BA2. And then the tribunal set out the text of Regulation A13 as it came into force on the 1st of April 2013. Come back to that in a moment. But the tribunal then describe in paragraph 11 of the decision, decision makers must accordingly determine a claimant's maximum rent in accordance with B13 2 to 4. The first step in that process is to determine the individual's limited rent by going through the 3 stages set out in Regulation B13 2. Step 1, subparagraph 2 little a, is to work out that person's eligible rent, i.e. in terms approaching plain English, the contractual rent minus any ineligible service charges, see Regulation 12B2. Step 2, subparagraph 2b, is, if appropriate, to apply the relevant percentage deduction of 14 or 25%, see subparagraph 3, where the number of bedrooms in the dwelling exceeds the number of bedrooms to which the claimant is entitled in accordance with paragraphs 5 to 7, emphasis added. Step 3 is to apply apportionment, where the claimant shares liability for the rent with another occupier or occupiers, subparagraph 2c. And if the court then looks back across the page, as it were, to MS 204, the text of Regulation B13 as it was originally, you can see the structure which the tribunal has described in in paragraph 11. You determine 13.2a, the amount that the claimant's eligible rent would be in accordance with B2 without applying Regulation 12B4, which is to do with apportionment, or 12B6, which is to do with the rent being larger than would be reasonable for housing benefit to pay for. Neither of those issues arise here. And then B, where the number of bedrooms in the dwelling exceeds the number of bedrooms to which the claimant is entitled in accordance with paragraphs 5 to 7, reducing that amount by the appropriate percentage set out in paragraph 3. Paragraph 3 sets out the appropriate percentage, 14%, where the number of bedrooms in the dwelling exceeds by 1 the number of bedrooms to which the claimant is entitled, and B, 25%, where the number of bedrooms in the dwelling exceeds by 2 or more the number of bedrooms to which the claimant is entitled. And then you work out the number of bedrooms to which you're entitled in the original version of A13, according to A13.5, which is set out by the tribunal there. If you look at 5...
Sorry, where do we find that?
In the middle, it's A13.5 in the middle of MS 204. It's still in paragraph 10 of the tribunal decision.
Right.
Version that is there, if you look at 5A, it's a bedroom for a couple. So there is, as it were, no concession or nod towards the Carmichael situation where the couple cannot share the bedroom because of disability on the original drafting of the regulation. And then C, 2 children of the same sex. Sorry, no, it's actually D is the one that matters for understanding this, or I think both would potentially matter. 2 children of the same sex, C, 2 children who are less than 10 years old, D. There's no nod on that drafting towards what one might call the Gorry situation. I don't know whether the courts had a chance to catch up with that, but in Gorry, in relation to the private sector size criteria, the Court of Appeal held that D discriminated on the grounds of disability against the Gorry children who had behavioural problems arising from their disability and therefore couldn't share a bedroom. So the size criteria were falsified in relation to D. Regulation did include a nod towards adult carers in the 12.6a, already provided by April 13, that where an adult was a person who requires overnight care, you've got a bedroom. All of that is subject to elaborate provisions in the definitions, and I'll show your lordships and my ladies where to find them in the present version in just a moment, but I don't want to spend a lot of time going through them because the drafting is complicated. My time, to be honest. But missing from that version is a position where it's a child who requires a carer, which is what was put right in the Rutherford case by the Supreme Court. Because the child won't be the claimant, and he won't be the claimant's partner. Put right by the post-litigation amendments. So the effect of the case law, to which I'm going to come very shortly, is effectively to falsify the size criteria, both in situations where a couple cannot share a bedroom because of their disability, or where, at this stage, a child needs an overnight carer. The carer won't count in the ordinary assessment of people who need bedrooms within the assessment unit for benefit purposes. Because the carer may not even be one person, there may be a team who just need a bedroom from time to time as they use the room, but you still need the bedroom. Anyway, that's the structure. I don't propose to spend much more time dealing with the further evolution of the regulations. That's what we've covered in the note. I don't think anything turns on it. Having made the observations about the steps that were involved in the decision-making structure in paragraph 11 at MS 204, the tribunal then recorded my submission, which I stand by, is the submission I make today and continue to make, in paragraph 56 of the tribunal decision, which the court will find at MS 216. And 56 reads, Mr. Drabble did not seek to support the reading-in methodology adopted by the tribunal in the present case. His central submission was that the analysis of Lord Wilson in paragraph 48 of his judgment in Mathiasen could be applied in the same way to the operation of B13 in the context of Mr. Carmichael's appeal. Mr. Drabble argued that the lawful starting point in the latter case was the requirement in B13(2)(a) to identify the eligible rent. The problem came with the statutory directive to make a reduction under B13(2)(b), as the Supreme Court's decision in MA and others made it plain the decision to make such a deduction in circumstances such as the Carmichaels was necessarily unlawful, as the application of the social housing size criteria in B13(5)(7), where a couple could not share a bedroom because of disability, unlawfully discriminated on the grounds of disability. There was no obligation in the primary legislation to make such a reduction, rather the requirement was contained in the secondary legislation. However, Mathiasen demonstrated that in such circumstances the tribunal should allow the appeal, set aside the offending decision by the initial decision maker, and substitute a decision that the claimant was entitled to the continuing payment of benefit at a rate unaffected by the action, which would otherwise be a breach of the claimant's convention rights. Thus, Mr. Drabble concluded in his skeleton argument where delegated legislation proceeds by requiring the lawful calculation of an amount, here the eligible rent, and appears to mandate an unlawful deduction from that amount, it is a duty of both the original decision maker and the FTT on appeal not to make the deduction and will benefit at the full rate. And there's a rather optimistic comment by me that's recorded. As a result, he contended it was unnecessary to engage with the broader constitutional jurisdictional arguments on behalf of the Secretary of State. I'm not sure that last bit's necessary, but the first bit of the analysis is precisely the analysis which Lord Justice Leggett, in the minority in the Court of Appeal, on appeal from this decision, adopted, set out for his own, in his own terms, but which I say is the correct analysis. So on this first part, how do the size criteria work? The other stepping stone at this stage is to ask the court to look at Carmichael's stroke MA. It's called various things, but the Carmichael decision in the court, in the Supreme Court, in the judicial review, which is in the authorities bundle, bundle 1 at tab 11, and I think we can go straight to MS 606.
Did you say 606?
606, yep, sorry.
Yeah.
And we are in the judgment of Lord Toulson, and the passage is the passage from paragraphs 41 through to 48. And it may be worth noting 41 because of a submission made by the Secretary of State in his statement of case for this court for today's hearing, to the effect that there were other people who couldn't share a bedroom other than the Carmichaels. The broad contention on behalf of the large group, as Baroness Hale will recall in MA and Carmichael, was that there was discrimination on the grounds of disability against a large group for a whole variety of different reasons. And Lord Toulson said about that, in MA, the Divisional Court and the Court of Appeal concluded after careful scrutiny that the Secretary of State's decision to structure the scheme as he did was reasonable. In general terms, I agree. There was certainly a reasonable foundation for the Secretary of State's decision not to create a blanket exception for anyone suffering from a disability within the meaning of the Equality Act, which covers anyone who has a physical or mental impairment, which has a more than minimal long-term effect on the ability to do normal daily activities, and to regard a DHP scheme as more appropriate than an exhaustive set of bright lines to cover every contingency. However, that is not the end of the matter, for there are some people who suffer from disabilities such that they have a transparent medical need for an additional bedroom. Burnip and Gorrie were in that category. Even before the decision in those cases, there had been an amendment of the regulations to include one additional bedroom in any case where the claimant or claimant's partner is a person who requires overnight care, or in any case where both of them are. Burnip was such a case. So Burnip was a case where there was an adult who needed an overnight carer. Gorrie was a case where children required separate bedrooms for disability reasons. As I've already said, the two Gorrie children couldn't share because of behavioural problems arising from their disability. In those cases which were rightly identified by the Court of Appeal as ones where the individual's medical condition was easy to recognise and gave rise to a need for a separate bedroom, there was no reasonable cause to apply the same cap on housing benefit as if the bedrooms were truly underoccupied. And Mr. Justice Henderson said that such cases were likely to be few, but I do not see that as a significant factor in itself. That brings me to the cases of Jacqueline Carmichael and the Rutherford family. They are the counterparts to Gorrie and Burnip, respectively. Mrs. Carmichael cannot share a bedroom with her husband because of her disability. Her position is directly comparable to that of the Gorrie children, who could not share a bedroom because of their disabilities. But Mrs. Carmichael's caught by Regulation B13, because paragraph 5b, little ba, which is introduced to meet the Gorrie situation, is confined to a child who cannot share a bedroom. The Rutherfords need similar overnight care for their grandson who has severe disability. Their position is comparable to that of Mr. Burnip, who needed an overnight carer. But the Rutherfords are caught by B13, which because paragraph 6a, which covers the Burnip situation, does not extend to a child who requires overnight care. There is no reasonable justification for these differences. The Court of Appeal was persuaded that there was an objective justification for treating Mrs. Carmichael less favourable than a child in like circumstances, because the best interests of children are a primary consideration. I can see there may be some respects in which the differential treatment of children and adults regarding the occupation of bedrooms may have a sensible explanation. Expecting children to share a bedroom is not the same as expecting adults to do so, but I cannot, with respect, see a sensible reason for distinguishing between adult partners who cannot share a bedroom because of disability and children who cannot do so because of disability. And the same applies also to distinguish between adults and children in need of an overnight carer. There's also an ironic and inexplicable consistency in the Secretary of State's approach to the Carmichael and Rutherford cases, which Chief Justice Lord Thomas exposed in the latter at paragraph 73. And the court will see that that quote ends with the basis. On that basis, it seems to us very difficult to justify the treatment within the same regulation of carers for disabled children and disabled adults, where precisely the opposite result is achieved, provision for the carers of disabled adults but not for the carers of disabled children. And then 48, Lord Thomas added that the court accepted the DHPs were intended to provide the same sum of money, but it was not persuaded that justified the different treatment of children and adults in respect of the same essential need within the same regulation. I agree. So, just stopping there, what one is looking for to get out of the general approach which is legitimate set out in paragraph 41 is a transparent, objective medical need which falsifies the size criteria because it demonstrates that the assumption about who can share a bedroom that are in the size criteria are falsified. That's now done in the present set of regulations, which are at tab 2 of the authorities bundle, by definitions relating to receipt of disablement living allowance and other drafting, but the essential quest is whether or not the size criteria reflect the reality of the position. And if they don't, because of disability, then Burnip and Gorrie and Carmichael and Rutherford read together establish that there is a breach of convention rights because of discrimination on the grounds of disability. While we've got this passage open, paragraph 41 is Lord Toulson's description of the broader case that was being advanced by the claimants other than Rutherfords and the Carmichaels. If the court looks across to paragraphs 50 through to 53, you will see the description of the position of the other claimants, which were very different. 53, for example, is dealing with JD, where the facts reflected a common problem, where a lot of money had been spent on specially adapting accommodation, which had more bedrooms than were necessary. So the claimant's case was it's unreasonable to expect us to move. That is discrimination on the grounds of disability. Court essentially holds, no, that can be dealt with by DHPs. The ladies and my lords will see, just below letter H, or at letter H, they have no objective need for that number of bedrooms. The problem wasn't the size criteria being falsified, it was a different problem. And Mr. Drager's problem, recorded in paragraph 52, is even more removed from the need for an extra bedroom. He occupied the bedrooms in order to hoard.
Do we need to go into these?
Well, I'm only doing it because the Secretary of State says there is a difference between I've stopped now. I mean, but the Secretary of State's case appears to be that the other claimants had a need for another bedroom, which they simply don't. It's a misunderstanding of the fact. But done it. Let's stop. Right. So that, I think, that is what I need on the size criteria. The next stop is the HRA.
Don't you need what the Supreme Court actually decided?
Well, I'm sure I do. Let me go back to tab 11. Well, it's 49.
Yeah.
Sorry, I should have gone on to 49. Yes.
Well, it's pretty crucial, isn't it?
Yes, I mean, yes is a simple answer to that. It is the foundation of all my submissions. If I haven't managed to say it, then so be it.
Well, isn't it effectively saying that the requirement of a deduction in those two cases,
yes,
the Carmichael and Rutherford cases, is unlawful?
Yes.
The regulation is unlawful.
No. That's the non sequitur which I don't accept. The regulation is perfectly lawful because it will apply to a vast number of cases in which the breach of convention rights...
I wasn't saying...
The application in that case...
As it required the deduction in those two cases.
Yes, then that application is unlawful. I mean, it's possible to get bogged down in semantics, but it's not my case that A13 is in any sense unlawful as such. And I fully accept that the statutory authorities would not have the power to strike it down or hold it generally ineffective. What it can do is hold that the decision of Sefton in the Carmichael case, it was in fact Sefton by one happenstance, was unlawful, as is said in 49. In her case, there's been a violation of Article 14 read together with Article 8. Now, there will be the same violation in each and every case in which the size criteria are falsified by a transparent medical need for an extra bedroom. But the decision for the individual decision maker is that the application to the facts of that case are unlawful. We'll see this theme recurring all the way through. This Carmichael was, of course, a judicial review. So the relief that was granted in the end was a declaration.
Where do we find that?
I'm just looking. Not sure that I can find it very easily. I'll make that good. But I do want to come back to the fundamental distinction between this Carmichael, which is the judicial review, and Remedies Carmichael, which is the statutory appeal, because translated across, it is entirely correct, take me to paragraph 49, translated across Lord Toulson's comments in paragraph 49 that he held in her case as being a violation of Article 14 taken together with Article 8. Translate into a statutory scheme where someone addressing whether the Sefton decision made in March 2013 was unlawful, the answer is yes. The decision in RR's case or Mrs. Carmichael's case, that their benefit should be calculated with the deduction is unlawful because of the provisions of the Human Rights Act, which is my next port of call. It's not a general striking down of B13, which is perfectly lawful in relation to a very large range of factual situations.
Regulation stands, but it cannot be applied
to this individual. There may be lots of these individuals, but the foundation is in relation to the individual decision-making in the statutory scheme for decision-making, is that you can't make the deduction. You, public authority, can't make the deduction because to do so is unlawful. Unlawful, see Section 6 of the Human Rights Act. Now, you could call that disapplication, or you could use whatever language you want to describe it. My submission is that it doesn't matter. It's the result that matters. It's just unlawful. We'll see, that's exactly the way Matheson works when we get onto that, right? Very early port of call. So, can I then go to the HRA? I mean, the court would be terribly familiar with the provisions, but can I just use them as an agenda? The HRA is at tab 1 of the authorities bundle. Relevant provisions that are in place. Section 3, which is an interpretive obligation applicable, of course, to all primary and all secondary legislation. Then section 6, unlawful for a public authority to act in a way which is incompatible with a convention right, 6.1, and then 6.2 is the exception where the result is mandated by primary legislation. Now, our simple submission, foreshadowed in the submission in Carmichael, is that in RR, Sefton, in making the decision it made in March 2013, applied the deduction. We know from paragraph 49 of Carmichael that to do so was unlawful in RR's individual case. And we say it follows the FTT, seized of an appeal against that unlawful decision, had to allow the appeal. It did, in fact, by using section 3, I accept wrongly. Crisp issue that emerges for the Secretary of State is what he says the status of the decision made by Sefton in March 2013 is. His case is that Sefton had no choice but to make that decision, had to apply the deduction. The rhetorical challenge I throw out, does it follow from that case that he is submitting that the Sefton decision was lawful? As my submission, that flies in the face of paragraph 49 of Carmichael. We'll see what the submission is. I've been saying that for some time now and haven't had a crisp answer yet as to what the Secretary of State's case is about the status of the initial decision. Then section 8 states, in relation to any act or proposed act of a public authority which the courts find is or would be unlawful, it may grant such relief or remedy or make such order within its powers as it considers just and appropriate. So stopping there, you need an unlawful act to get into the section 8 jurisdiction. Section 8 jurisdiction, I do mean that. And the scope of the section 8 jurisdiction is that the tribunal or court or public body, whatever it is, the court of the court actually, can grant such relief within its powers it considers just and appropriate. So 8 is confined to courts, wouldn't apply to Sefton as its initial decision maker, which may be an important issue when we come to the second issue. Only bites where there's an unlawful act. Where there's an unlawful act, a court which has power to award damages can award damages. See 8.2 and 8.3. Secretary of State's case on the primary issue is that the Carmichaels and RR and the Rutherfords and so on should have sought damages rather than the remedy in a statutory appeal. I don't want to say you can't get damages, but it's quite difficult to see what the unlawful act is on the Secretary of State scenario. Is the first decision of Sefton lawful or unlawful? If it's unlawful, surely the FTT should allow the appeal. If it's lawful, where's the Section 8 jurisdiction come from at all? Well, no doubt Sir James will tell us the answer to that, but I've been saying this for about 2 years now and not had an answer.
Just ask how the scheme works on a statutory appeal. At the end, if the court decides that a different decision should have been made, does it make that decision or does it send it back to Sefton to make the decision?
It can do either. I wasn't going to go into the detail of it, but I'll give you your ladyship the structure in just a moment. But these statutory appeals, the Court of Appeal steps into the shoes of the upper tribunal. The upper tribunal here allowed the appeal against the FTT on the basis it erred in law by using Section 3 rather than Section 6. So it then becomes the first instance decision maker. It has a discretion at that stage whether to send it back or to do it itself. And on pure law, it will tend to do it itself for fairly obvious reasons. Court of Appeal has the same powers as the upper tribunal. There's nothing express about the powers of the Supreme Court.
Yes, I suppose I'm thinking ahead to issue 2.
I think you are.
Question.
Well, yeah, you are. But my submission on issue 2, as I've already said, is that the order actually made by the upper tribunal dealt with the issue that was in front of it, entitlement. Didn't deal with payment, but that's because an issue for payment is for the paying authority, i.e. Sefton, who aren't here. So I would say that you simply simply allow my appeal, and that leaves in place the upper tribunal's order. If the Secretary of State is right in some way on issue 2, I have another rhetorical challenge where he needs to tell us exactly how he says the machinery works in his view on issue 2. But I can see that you could get to a place where it's going back to a fact finder, which of course this court isn't. The fact finder would be the upper tribunal. But go back to the upper tribunal, the FTT or Sefton, depending on what you wish to do. So, those are the principal provisions. Just one further comment on the drafting of these provisions. Section 6.1 doesn't use language which suggests at all any need to talk in terms of linguistic severance between the provision. If the provision, however expressed, whatever machinery is used to apply the size criteria, produces an unlawful answer, then it is unlawful. That's what 6.1 says. And there is, in my submission, no need to get more complicated than that about severance. So that's the HRA. The decision-making structure, if the court will pick up our printed case, at MS 102, paragraph 4 at the foot of the page recites the duty of the housing authority to make a decision on a claim for benefit. The decision notice that Sefton issued making the deduction is obviously in the papers. There's an appeal to the FTT by version of section 6, paragraph 1 of Schedule 7 to the
I'm sorry, I've obviously got the wrong page number because I wrote down 102, but you're somewhere else.
No, MS 102, I don't think I am. The very foot of the page, Regulation 89 of the HB regulations imposes on the duty.
Yeah.
Right, okay.
And it's just over the page to 103 is the continuation of paragraph 4. It's actually on 103.
Thank you.
It just provides for a right of appeal. There is authority in RIB 2/04, which we refer to in paragraph 5, which is at MS 1028. I'm just going to give you that for note-taking purposes at the moment. RIB 204 holds that the hearing in front of the tribunal, the FTT, is a complete rehearing in which the FTT, to use the language of the decision, steps into the shoes of the original decision maker. So we say SEFTA make an unlawful decision in March 2013. The FTT must hold that decision to be unlawful and therefore allow the appeal. Can't do as the Court of Appeal thought it could, just declare the whole thing, the whole regime to be non-convention compliant, because the tribunal doesn't have a power to make that sort of declaration. It can only exercise powers in relation to the individual case. That's its job. I don't think I, at the moment, need any more of that. The final stopping off point is Foster, dealing with the powers of tribunals in cases of conventional ultra vires arguments. You will find Foster at volume 1, tab 12.
Mr. Drabble, I've just been thinking about your observation, I'm afraid about 10 minutes ago, that the regulations were not unlawful. And I'm just wondering about that. The power to make the regulations is a power conferred on the Secretary of State by the 2006
the power to make the regulations originally is the 1992 Act. It is Section 130 large A, I think.
Right.
But anyway, it's certainly contained in the Social Security Contributory Benefits Act.
Now once the Human Rights Act came into force, wouldn't that power, in order to be exercised lawfully, have to be exercised in accordance with convention rights?
Well, it doesn't need to, well, my answer to that, it doesn't need to be exercised in accordance with each and every individual's convention rights, precisely because Section 6 produces an answer for the individual who is adversely affected by a non-compliant regulation.
It is, but the problem in Carmichael was structural. It was in the legislation itself, but no allowance was made for, what was it, 6BA,
yeah.
if I remember correctly, made provision for children in a certain position following Gorry, but there was no provision made for adults in an equivalent situation.
Yes, but we need to be slightly careful with that. I know that's the way the Secretary of State puts it in his Pinto case, but the result is that you go back to the underlying discrimination discerned in Burnip and Gorry. Look at it in detail if time permits. The underlying discrimination is that the size criteria discriminate against the disabled as such, because they fail to make provision for the objectively verifiable housing needs of the disabled,
Yes.
as opposed to the able-bodied.
Fine.
Then you get a legislative history in which that's put right in relation to children in one case, in relation to adults in another case. And Lord Toulson and the rest of the Supreme Court hold that's not a sustainable position because there's no difference between the children and the adults. You're still going back to the regulations producing an effect which is unlawful and which is correctable on appeal under Section 6 in relation to the individual case.
Well, you know, I quite see that a tribunal that doesn't have jurisdiction to quash may well have jurisdiction to disregard on a Boddington approach. But at the moment, I'm still left wondering whether if the power to prescribe X, Y, and Z is exercised in a way which, in terms of legislation itself, discriminates against the disabled, whether that should not be regarded as an unlawful exercise of the power, contrary to Section 6 of the HRA, which and consequently vitiates the legislation.
Pro tanto.
Yeah.
Well, it's the pro tanto that I struggle with this. I'm not sure that it matters. is what you can't do, you, the legislature, the Secretary of State rather, can't do is produce a measure which, when applied in the individual case, breaches our Convention of Rights. Now, I've certainly submitted in the past, I think in relation to the financial qualifications in the immigration rules, at 25,000 or whatever it is, that if you, the Secretary of State, make a set of regulations which, in a very large number of cases, is bound to produce a discriminatory effect, the actual law-making power is vitiated. That may not be right. I don't know there's never been a need to rule on it. But here, we are, in fact, concerned not with the overall legality of A13, but with how it applies in the individual case, in the task being carried out by the statutory authority.
But aren't you, in fact, involved with a very clearly defined set of circumstances, which is that making the deduction in the two cases, the Carmichael and Rutherford cases, i.e. a clearly defined medical need for another bedroom, was unlawful.
Yes.
Now, you could say that it was the regulation which required that was unlawful, not in other respects, but in that respect it was unlawful.
I think my short answer is I don't mind.
Well, it's pretty crucial to your the second issue.
No, well, can we come back to that when you understand? Sorry, I don't mean that pejoratively, that sounds very rude.
Lord Reid and I are trying to help you.
Might this be an example of ultra vires, actually, on that basis? Which is a well-established
whether to
category.
accept this gift horse, but
Yes. That's the implication of the question I put to you, that the vires conferred by the 1992 Act have to be understood football post-2000 as being subject to a condition of compliance with convention rights.
well, can I follow your lordship and think about that for a few minutes while I make the rest of my submissions? For reasons I've tried to explain, I don't think I need it on the second issue, but because however you look at it, the Sefton decision is unlawful, and therefore the tribunal can't apply the size criteria. Foster, we were going to, which is the source of the, obviously, Secretary of State's argument, and indeed the Court of Appeal argument.
You did say the regulations were where you were going, I think. But
Foster is a traditional severance case. I mean, it's a traditional case about Vives, and it's only relevant, but it's quite an important relevance, to showing that these sort of statutory authorities have the power to decide each and every issue that arises in front of it in order to quantify the entitlement to benefit. I won't spend time on Foster, but
And I suppose, I mean, there are two juridical bases on which you could say the tribunal shouldn't make the deduction prescribed in the statutory instrument, and one is to say that insofar as the statutory instrument requires that deduction, it's unlawful. The alternative is to say that the statute, the Human Rights Act itself, makes it unlawful for the tribunal to do that, regardless of all other questions in the case. You have primary legislation saying it's unlawful for you to do this.
yes, well, it's the second. I mean, as is obvious, the second is the analysis I've been pursuing, and I understand what your lordship is putting to me about the possibility of an ultra vires analysis. But my reaction so far has been we simply don't need it, because I mean, there are two very short paragraphs in Matheson which are very condensed, but which, in my submission, think this through. We'll come to that I'll come to that next, actually. But on Foster, the detail of which probably doesn't matter, but the passage is at 766B, internal 766B, MS 634. It's at letter H, foot of the page. My conclusion is that the commissioners, this is Lord Bridge, have undoubted jurisdiction to determine any challenge to the vires of a provision in regulations made by the Secretary of State as being beyond the scope of the enabling power, whenever it's necessary to do so in determining whether a decision under appeal was erroneous in point of law. I am pleased to reach that conclusion for two reasons. And then there's a discussion about avoiding duplicity. I don't think I need any more for now, at least. So the conclusion I draw from Foster is that in traditional vires cases, the tribunal, the original decision maker, even if it was the Secretary of State who made the regulations, must decide vires issues. If it's necessary to quantify the claim. If we then go on to Matheson.
The commissioner in question being the Social Security Commissioner.
Yes, absolutely. Yes, sorry, I should have.
Basically, the upper tribunal.
Yes, absolutely.
Sorry, you were taking us to Matheson.
I was going to take you to Matheson. It's MS 941. So it's volume 2 of the authorities bundle. Can I just draw attention to the facts which are set out by Lord Wilson in paragraphs 5 to 6 at 946. And though I won't read 5 and 6, they're recording the very intense involvement of Cameron's parents in providing for the care of Cameron, even though he was in hospital. The court will recall that the issue in Matheson was that DLA was suspended after, I think, an 84-day period.
84 days.
It is an 84-day period of inpatient stay in a hospital on an overlapping benefit sort of analysis. But there are the facts, and then going on to the two condensed paragraphs, 48 and 49, says, I conclude, therefore, that, 48, A, by his decision dated the 3rd of November 2010 to suspend benefit of DLA to Cameron, the Secretary of State violated his human rights under Article 14 of the Convention, taken together with A1P1. B, there's therefore no need to consider it also violated Cameron's rights under Article 14, taken together with Article 8. C, in that the Secretary of State was not obliged by any provision of primary legislation to suspend the payment he enacted unlawfully in making the decision dated the 3rd of November 2010. D, accordingly, the first-tier tribunal should have allowed Cameron's appeal against that decision, should have set it aside, and if only for the sake of clarity, should have substituted a decision that Cameron was entitled to continued payment of DLA with effect from the 6th of October 2010 to the date from which payment of it was reinstated. Indeed, this court should allow Cameron's appeal and make the orders at D, which the first-tier tribunal should have made. Now, we say, just applying that, the Sefton decision to apply the deduction in respect of the size criteria is the equivalent of the 3rd November 2010 decision to suspend DLA. We know on binding authority that that breaches RR's convention rights under Article 14, read together, in fact, with Article 8. Consequence in this tribunal decision-making structure is that the first-tier tribunal should have allowed Cameron's appeal against that decision, should have set it aside, and substitute a decision it could have made. Now, it can do that in a variety of ways. It could make a declaration in the lower key sense of just saying what the individual entitlement to benefit is in the individual's case. It could just simply have said, RR is entitled to benefit, or the amount of RR's maximum rent is X, or whatever. And then 49, Mr. Matheson seeks further relief, which the Secretary of State energetically opposes. First, he seeks a formal declaration the Secretary of State violated Cameron's human rights. The first-tier tribunal had no power to make a formal declaration. It appears that by virtue of sections 12.4 and 14.4 of the 2007 Act, the jurisdiction of the upper tribunal and the Court of Appeal in relation to Mrs. Matheson's successive appeals was no wider than that of the first-tier tribunal. It may well be that this court is not similarly confined, but a formal declaration would seem to add nothing to the conclusions articulated at A and C of 48 above. Second, more controversially, Mr. Matheson asked this court to discharge its interpretive obligation under Section 3 by somehow reading in the provisions for suspension of payment so as not to apply to children. In my view, however, it's impossible to read them in that way. Anyway, as Secretary of State points out, it may not always follow that the suspension of payment of a child's DLA following his 85th day in hospital will violate his human rights. Decisions founded on human rights are essentially individual, and in my judgment, is an attempted analysis of Cameron's rights, undertaken in the light, amongst other things, of the extent of the care given to him by Mr. and Mrs. Matheson and Alder Hay. Although the court's decision will no doubt enable many other disabled children to establish an equal entitlement, the Secretary of State must at any rate be afforded the opportunity to consider whether there are adjustments otherwise in the form of abrogation of the provisions for suspension by which he can avoid violation of the rights of disabled children following their 84th day in hospital. So my reading of that, and on which my approach has been based, is that the suspension is not automatically unlawful, the provision providing for the 84 days. You need to examine the underlying individual facts. If on the underlying individual facts it produces a breach, then the decision of the 3rd of November 2010 is unlawful. Tribunal should allow the appeal and substitute its own decision on the entitlement, and that's precisely what I'm inviting this court to do. Now,
Of course, you could understand why in Cameron Matheson's case, it was the particular facts relating to the amount of care that his parents were giving him in hospital, which meant that to apply the 84-day rule was unlawful. Whereas what we've got, arguably at least in this case, are not particular facts. They are facts that could apply to many couples, and in any case where they would apply, it would be unlawful.
I mean, what your ladyship
It's not an evaluative thing, is what I'm getting at.
Yeah, I mean, following on from my promise to continue to think about this, I mean, what your ladyship is actually putting to me is that you could attack the size criteria as such, because there's a discernible class of people, as demonstrated by Burnett, Trengrove, etc., to which the assumption that a couple can share a bedroom is demonstrably false in each and every case. I mean, that's what's being
Yes,
put.
that's the point.
So
It's essentially the same point that my lord was.
Well, it is, yeah. I mean, I don't understand. I'm just getting my own head around it. Well, so be it. I mean, I'm certainly not going to resist the court going down that road. It's my approach so far has been I don't need it, because whatever else you do, whatever else the Secretary of State says, he can't say, well, he might attempt to say, but he can't actually say the original Sefton decision was lawful now, because it's binding authority that it wasn't. And then, once you do that, then you're into the Matheson analysis. And also in Matheson, there's paragraph 61 in the Judgment of Lord Mance at page 963. 61. With regard to the appropriate remedy to give effect to these conclusions, I agree that this should be tailor-made and limited to Cameron's particular position by simply declaring that the decision in his case cannot stand, and that he was entitled to continue payment of DLA after 84 days. Secretary of State may be able to refine the criteria for the receipt or cessation of DLA in other cases in a manner which involves inequity involved in its withdrawal in respect of those in Cameron's position. We cannot address in general declaratory terms the position of children receiving DLA and hospitalised for longer than 84 days. I suppose I'm following the discussion we just had. That's compatible with either approach. I mean, it's certainly compatible with the approach I've been following, but wouldn't get in the way of an approach that says these size criteria are irrational. They simply do not cover needs of a discernible class of individuals.
Your argument gets away from declarations of incompatibility and interpretative obligations, doesn't it? And I understand that, and the Act does take account for obligations on public authorities to apply human rights, to give effect to human rights.
Yes.
But as I understand it, it also uses the word so far as possible.
Yes.
That a public authority is obliged to give effect to human rights. And I haven't yet understood what, if anything, the words so far as possible involve for this case.
Well, they don't bite because we're dealing at most with an obligation imposed by secondary legislation not mandated by the primary legislation. So that if one goes back to Section 6.
Section 6.
Yeah.
Your case isn't based on Section 3. It's not to do with the interpretation of the regulations.
No.
But Section
It comes back again in section 8, a very similar phrase. I mean,
Yeah. I mean, yours is, as I understand it, is a Section 6 case rather than, I mean, it's an unlawful act case rather than, I mean, Section 3 might come into the argument I was putting to you about how you interpret the power to make delegated legislation in the 1992 Act, but Section 3 doesn't apply to the regulations themselves, because nobody's arguing that they can be interpreted as covering.
that's been abandoned. The FTT did actually did say we can interpret the size criteria so as to help the RR, but we've never pursued that at the upper tribunal level. So we say, and this is Lord Wilson's analysis as I understand it in Matheson, that you are in section 6.1, it's unlawful for them to act, for the authority to act in a way which is incompatible with the Convention right, unless you're protected by 6.2. And you're not protected by 6.2 in relation to the size criteria.
Yes, I wasn't going so far as to say this was exclusively Section 6, because Section 3.1 says that primary and subordinate legislation must be read and given effect. So there are two independent provisions in 3.1,
Yes.
so that decision makers are bound by 3.1, even if they can't interpret. Because they've got to give effect to legislation.
Yes, but the giving effect to is, as your ladyship says, subject to the opening word, so far as it's possible to do so.
Right.
So you will get to a point where if you're dealing with just primary legislation, forget the complication about it being subordinate legislation not mandated by the primary legislation, there will be incompatible pieces of primary legislation which the interpretive duty in Section 3 just can't get you out of. You're obliged by the primary legislation. It's not possible to give effect to the primary legislation in a way which is compatible with Convention rights.
But what role then do the words "and give effect," must be read and given effect, play in Section 3?
If you have an unambiguous piece of primary legislation, so it's not possible to read it compatibly with Convention rights, then it's not possible to give them effect in a way which is simply an effect not produced by the legislation.
That's separate from the interpretative obligation in 3.
Well, I would require more warning of that. I think
I'd be grateful for some assistance, because then that leads on to the question, what does "so far as it is possible" mean?
Well, let's answer it on the facts of this case. We have accepted, I'm not drawing back from the acceptance, that the solution produced by the FTT in both Carmichael and indeed in RR, which was to read in words into the size criteria, which effectively created another group of people.
Is not interpretable.
It goes beyond
Yes.
the Section 3.1, the possibilities of interpretation under 3.1. I've worried a bit about that from time to time, but I mean, that is what we've accepted. I stand by it. It doesn't matter, because assuming that the size criteria are unambiguous, and for all the reasons we've been discussing, their application to mandate the 14% reduction breaches the individual's Convention rights, and therefore the public authority acts unlawfully in applying them.
It still leaves me with a slight concern. You haven't given meaning to the words "and given effect." Because elsewhere in the Act they're used with disjunctively with "read."
Well, implicit in that thought is that read and given effect to is a composite phrase, which is an interpretive obligation, as a side note says.
It's not directed to decision makers who
You
can't
can't.
properly interpret.
I certainly do not submit that you can use Section 3 to say, I can't avoid the meaning of the words, but I can give effect to them in a different way, because you're not, in that case, interpreting the statute at all. You're not giving effect to the wording of the legislation. You're doing something completely different. That's
Can I just follow on from the ultra vires line
Yes.
of argument for a moment, which does seem to me to produce I'm very quick about it, and it's probably a question that needs answering later, not now, as to whether there is any case in which subordinate legislation has been approached in this way by saying that there wasn't the power to make it because it, in a category of cases which is readily identifiable, would violate human rights inevitably. Let's put it at that extreme
I understand that.
formulation.
The nearest I can think of, and it might be worth, I haven't looked at it in this context at all, is the litigation about the financial requirement that a spouse entering the United Kingdom had was entering to join a spouse with an income of whatever it is, the now 32,000. But
Is that rules or statutory instrument? Was that rules or...
BB comes to mind.
Well, it was immigration.
Immigration
Oh,
rules.
certainly immigration rules.
Statutory instrument.
Doesn't...
Oh, I see what you mean. Yeah.
Anyway, I'll leave it with you.
Yes, I suppose. I mean, I certainly had a submission in front of Mr. Justice Blake in that case that the rule was ultra vires
Rules
for precisely the reason, but I wasn't in it by the time it got to the Supreme Court.
I think in Northern Ireland, for example, there is a statutory provision that, to some effect, that anything which is against human rights is not going to be valid. But the fact that that exists is interesting in the context of this submission. Anyway, I'm quite happy to leave it and have the answer later.
I'll self-evidently have a think about that, but I mean, I should say, I mean, I decided we didn't need to go to it, but there is in the bundle of authorities an article by Philip Sales and Robin Allen, QC, Philip Sales being the Treasury devil at the time, which is fundamentally about how you construe the empowering provisions that predate the HRA. It might be worth having another look at that. I don't think it's going to give a crisp answer to Lord Reed's formulation. It may be that, maybe thinking about it, that the best answer is actually domestic rationality. If you're attacking the size criteria, they're obviously drawn up on the assumption that on a bright line basis, it's reasonable to expect 2 children under 10 of whatever gender to share, a married couple to share. But anyone in the business has known for a very long time that there will be married couples who can't share. Dementia is an obvious example. You've got to be careful with that because the criteria don't apply to pensioners, but anyone with suffering from that sort of disability below pension age is not going to be able to share the bedroom. Now, I've got 10 minutes. Right. Now, I suspect I need the 10 minutes on the last point, actually. But can I just take the court through the Court of Appeal remedy, Court of Appeal in Carmichael, just to highlight the passages that matter, and then a last word on the second point. And you will find Carmichael Court of Appeal starting at MS 167 in the core volume. The approach of the majority can be seen at MS 182, internal page 3444. And in my submission, the basic mistake that was made by the majority of the Court of Appeal can be seen from paragraphs 46 at MS 183, where Lord Justice Flo holds that there's no material difference between the approach of excision of words from regulation and the approach of the first-tier tribunal of adding words to the regulation, both impermissible rewriting of the regulations going beyond any permissible interpretation of the legislation under Section 3. So it's essentially equating what the upper tribunal did, which was under Section 6, with the limits of the power under Section 3. That shot all the way through the argument in the Court of Appeal, and in my submission is the basic mistake. And then 48, the same effect of rejecting my argument I've just outlined based on Section 6. Now, the answer given by Lord Justice Leggett is set out in the passage that starts at paragraph 86, MS 193, and he says in paragraph 88, this is really the core of it, cases under the Human Rights Act, that's MS 194, cases under the Human Rights Act, the potential for such an individual solution is built into the scheme of the Act. Section 6.1 applies to an act of a public authority and not to legislative provisions as such. What is made unlawful by Section 6.1 is for a public authority to give effect to or enforce legislative provisions when to do so is incompatible with a convention right. There is no requirement that the provisions which have the effect in the instant case should also have that effect in other cases or should be capable of severance. Now, we say that's exactly right. He then goes on to deal with a variety of cases in which that approach has been applied. I won't, for timing reasons, go to them. First of them is Francis, which is a case about entitlement to maternity grant, where the claimant had a residence order. It's a statutory appeal in precisely the same way as this case. Authority is at volume 2 of the authorities bundle, tab 15, starting at MS 763. What the court did in Francis was declare that the individual claimant was entitled to the maternity grant. So it granted a declaration, which on the face of it has no power to do, but it did so by reference to the individual circumstances of the claimant's case. And we say that's exactly the same as the order in Matheson. And so does Lord Justice Leggett, importantly. And the next case is in Re G, which the court will find at Authorities Bundle 1, tab 21, MS 970, and the relevant paragraphs are paragraphs 1, 2, and 3 in Lord Hoffman's judgment, paragraph 116 in Baroness Hale's judgment. And the quotation from Baroness Hale's judgment is set out in Lord Justice Leggett's judgment at paragraph 116. Just above paragraph 93. And this refers to Burnip. And then he refers to Lord Reed's comments in paragraphs 153 of T, the application of T against the Chief Counsel of Greater Manchester Police. Court will find that bundles 2/23 of the authorities bundle, MS 1077 at MS 1131. Then it deals with Matheson. Now, we submit that on the first issue, that's all completely correct and all that is actually necessary to decide the first issue. It is followed, as the court will have picked up, by Lord Justice Leggett's own judgment in JT at MS 868, which will be in volume 2 of the authorities bundle. In particular, if paragraph 127 and 128 at MS 904 I dissented in the Carmichael case. I did so because in my view there was no requirement that all the legislation is invalid and of no effect in a particular case. It must be possible to identify there's no problem here, because we can have a point with the rule containing, say, roof rule is what it was called in the criminal injuries compensation scheme. You just struck that out.
Well, your time is up.
Yes. Well, can I'll trespass for 5 minutes just on remedy finally?
Well,
I'm in the hands of the others.
you're in the hands of the interveners.
I am in the hands of the interveners. And getting nods.
Well, certainly you are from Mr. Chamberlain. I'm not quite so sure. Anyway, let
from-
us not waste time. We can have
So
5 minutes.
Spend time with them again. Well, so what in my submission the court should do is identify the initial decision, which is the decision of the 5th of March 2013, benefit decision notice issued by Sefton at MS 232, I won't go to it. Size criteria, of course, came into force on the 1st of April 2013. The benefit decision applying the deduction is prospective, as is allowed for in the Social Security legislation. No issue could have arisen at that stage of DHPs, or paid or anything, simply an application of the size criteria. Unlawful, see Carmichael. So when you go to the FTT decision, which is nearly a year later, it won't take you to it, but it's MS 224 to MS 225, appendix. Court will find that that is concerned entirely with the application of the size criteria. It is not looking at all at payment of benefit, and indeed one wouldn't expect it to be looking at payment of benefit. Payment is not an issue for the tribunal. Calculation of entitlement is an issue for the tribunal. Accordingly, we submit that Sefton, acting lawfully, would never have applied the deduction. The FTT should have upheld the appeal on a Section 6 basis rather than Section 3 basis. None of those bodies are concerned with payment. So that if you go back, as it were, mentally, to the provision of Section 8 of the Human Rights Act, (8.1) is, as we've already discussed, concerned with power of court, not Sefton. It doesn't affect the position of the initial decision. Court to make one such relief or remedy within its powers if it considers just. Now, we say, translating that across to this statutory decision-making scheme, that reference to within its powers means in relation to the issues before it, which are entitlement, the amount of the maximum rent, not issues of payment. The tribunal isn't given by 8.1 the jurisdiction to range across all of the statutory responsibilities of Sefton in relation to how to benefit. We're dealing with the issue of an appeal against a defined decision made at a time when there was no issue of payment to DHPs at all. Now, the upper tribunal in Carmichael was obviously aware of the Secretary of State's argument about double payment. And if I will now ask the court to go to MS 159, where it's back in the core volume. And if we pick it up, without reading it for a moment, paragraphs 15 and 16 deals with the distinction between two cases that were in front of the judge at that time. RR being our case, where he was in receipt of DHPs for a period of about 18 months. Then he refers to inquiries to make the DHPs. And a lady will see after the upper tribunal hearing in Carmichael, written submissions on the question of double payment were invited. That's the very top of MS 160. Mr. Drabble stated in submission that Regulation 8 was drawn to the attention of the Court of Appeal during the hearing in Carmichael Court of Appeal, but no submissions were made on behalf of Mr. Carmichael on the meaning and availability of Regulation 8. That regulation is not referred to in any of the judgments of the Court of Appeal in Carmichael. That's correct. Both limits of that are correct. Then Regulation 8 is set out. We'll see in particular 8.2b provides potential recovery. An error has been made when determining the application for payment. As a consequence of that error, a payment has been made which would not have been made but for that error. It seems to be eminently arguable as if Mr. Lord Justice Leggett's primary conclusion was correct, and the upper tribunal as it did, then the following double payment could be met as follows, then essentially saying that there was an error in the payment of the DHPs because if the DWP had done it, if Sefton had done its job initially, housing benefit as opposed to the DHPs. My position is and remains that that is none of the business of the FTT, and it follows on the rest of the appellate structure. Hearing the appeal against the decision notice in March 2013. The issue in both Carmichael and RR is that both the Secretary of State and Sefton have indicated they do not wish to actually recover. So from their point of view, this all feels a bit academic. But I didn't feel it right in Carmichael to submit that there was a power to recover overpayments, when there might well not be, to be honest. That's a principle which I've outlined. Follows that unless someone explains what it is that the tribunal should have investigated in terms of fixing a maximum rent in relation to the DHPs, step-by-step analysis of how the regulations work in relation to fixing the maximum rent which is affected by the DHPs, then my submission on remedy is correct. If there is a solution to it, it lies outside this appeal. I think just 10 minutes. I'm sorry about that.
Yes, you're just about 10 minutes over. Well, we'll have to do our best.
Indeed.
Thank you.
If there's anything else I can help, my lady, and if there's anything else I can help on now, those are the submissions.
We will assume that Mr. Fraser is not going to follow you.
My ladies, I'll attempt to cut my time to try and avoid meeting Mr. Chamberlain had less time, but the Commission is grateful for the opportunity to intervene. And I was intending to address you on the position regarding subordinate legislation that can be severed, because at the moment, the authorities from the Court of Appeal, reading JT with the Carmichael case, is there's a distinction between two different types of subordinate legislation. And the two different types you were taken to, it may be worth just, if you still have it open, the judgment of Lord Justice Leggett in the JT case, at MS 903 to 904. And in paragraphs 125 to 128, he sets up a distinction with the Carmichael case. And the distinction essentially, one sees the language at the bottom of paragraph 125. It's between what he describes in Carmichael as a case in which there is no provision of the housing benefit regulation which a court or tribunal could put its finger on as incompatible with the Article 14 right. So that's how he explains the Carmichael decision. JT, the situation is in paragraph 127, just next to letter C, where it's possible to identify a provision of the legislation which is of itself incompatible with the Convention rights and hence unlawful. And the Secretary of State in these proceedings supports that distinction. She accepts that there will be cases where subordinate legislation has to be disapplied. Of course, there's many examples, G, Brewster, Mathias, and all Supreme Court cases, but she says there's a distinction. This is the Secretary of State's case, paragraph 31, MS 131. she says in certain cases it will be possible to disapply an offending provision which is an independent part of a relevant statutory scheme. And later on, this is at paragraph 59, she describes that as a severance approach. And our submission, briefly, is that that severance approach, or the distinction between severable and non-severable subordinate legislation, is not a sustainable one. We say it's wrong in principle. Secondly, it's arbitrary in practice. Thirdly, if one was applying a severance test in the ordinary public law sense, you'd end up with the exact opposite of the outcome that the Secretary of State is contending for, which is that if you can't sever legislation, which would otherwise be ultra vires, the whole thing is quashed, not the whole thing is saved. Fourthly, a severance approach is inconsistent with authority. And fifthly, we say it's premised on the wrong starting point in an HRA case, which is that you don't need to establish that a provision is ultra vires and generally inapplicable in order to disapply it on the facts of an individual case. So taking those briefly in turn, firstly, why we say it must be wrong in principle is because the outcome would then be that if you have subordinate legislation that couldn't be severed, a public authority, in this case Sefton Borough Council, would on the Secretary of State's analysis be required to follow it. But of course, that would mean it's required to act in a way that we know is unlawful under HRA section 6.1, and that would simply be incoherent. You can't have a position where a public body is required as a matter of law to do something that is unlawful. It simply doesn't make sense. Secondly, it produces arbitrary results in practice, because what it would mean is if you have subordinate legislation which would breach an individual's convention rights and the breach results from severable text, then the public authorities, courts, tribunals are able to disapply it. But in other cases, they would be required to apply it and required to act unlawfully. And what that would mean is whether the law is upheld would depend fortuitously on the way in which the subordinate legislation was drafted. Now, in fact, in this case, and you can see the happenstance or fortuity of it, because in fact, in this case, it is possible to identify severable text while the rest of the legislation remains intact. Certainly, Lord Justice Flo, this is paragraph 46 of his judgment, and the President at paragraph 106 of his judgment thought there was excisable text in this case. But also, if you have, I know you've seen it in different places, but in our printed case, we set out B13 as at the time, as in on the 5th of March 2013. It's at MS 2278. This is the time when Sefton was applying it. And, my ladies, my lords, if one looks, we set out paragraph 4. If you look at paragraph 5 of B13, you'll see that 5A refers to a couple within the meaning of Part 7. And the way the scheme works is each person is treated separately and they go through, and whichever is the first category they fall into, that's where they're counted. Now, if in a case such as the present, you simply deleted A, severed it, then Mr. RR and his partner would then come within B. They'd each appear separately. They'd each then be entitled to their own room. So in fact, in this case, by happenstance, you could sever words relatively easily to achieve a convention-compliant outcome. Third reason we say severance isn't the correct approach is if you're applying what, as we understand it's suggested to be, the ordinary public law severance test, that the starting point on ordinary public law principles is that if you have subordinate legislation that's ultra vires, it's struck down. Severance is then a concession to the legislature, or as Lord Lowry puts it in Hutchinson, a concession to practicality. So what it applies where you have subordinate legislation that would be entirely ultra vires, or provision would be ultra vires, but it can be saved because you're able to sever a particular provision, and then the rest can continue in force. But if the offending provision can't be severed, the answer isn't that the whole provision is saved. The answer is that the whole provision is quashed. And I don't have time to take you to it, but for my ladies and my lords' notes, that's clear from Hutchinson, particularly from Lord Lowry. He's concurring on exactly how severance works, whether it's textual or substantial, but in terms of how it operates in terms of saving, he's setting out the orthodox position. It's 818G to 819B at MS 1329 to 1330. That's where he used the phrase concession to practicality. Fourth reason we say the seventh approach isn't the correct one is because it's inconsistent with authority. And in particular, it's inconsistent with Mathiasson. And it's not only, because if that was the correct approach, not only would Mathiasson have been decided differently on remedy, but it would have been decided differently on the question of legality. And that is because, again, maybe to just to give you the submission and tell you where to find the relevant provision, is that the relevant provisions in Mathiasson were set out in Lord Wilson's speech at paragraph 12. It's at MS 948. It may help just to turn them up, maybe. It's in volume 2, tab 20. They're described in paragraph 12 by Lord Wilson. Essentially, the way the regime there worked was that Regulation 8 of the 1991 regulations provided that when anyone went into hospital, to an NHS hospital, their DLA would immediately stop. That was the care component. Regulation 10 then provided that for adults, or for those over 16 in hospital, that provision was suspended for the first 28 days. Their DLA would continue for 28 days. For someone over 16, it was suspended for 84 days.
Over 16?
Over 16, that's right. Under 16, 84 days. Over 16, 28 days. So in that case, if you were to sever, for example, the 84-day provision, what that would end up meaning is that children would lose their DLA as soon as they went into hospital. It's quite clear that in the Mathiasson case, it isn't possible to find some severable text that would have led to the result that Cameron Mathiasson should have continued to receive his DLA after 84 days. Fifth is, we say, the search for severability in this way is inconsistent with the way in which unlawfulness operates under the HRA, which ties in with some of the questions that were asked to Mr. Drabble earlier, which is, how does this operate? Do you need to have a provision that is ultra vires in order to subsequently disapply the provision? And our submission is that there may well be cases in which one can say that the making of the subordinate legislation is itself an ultra vires act. And it may be, we'll come on to a moment, this may be such a case where it operates within an entire category, for an entire category of people, it's inevitably unlawful. But we say that isn't necessary. It's not necessary to the analysis, because the starting point is Section 6, which is that a public authority must not act incompatibly with the Convention if there's no Section 6.2 defence. And whether or not the subordinate legislation under which they're acting is ultra vires because it would have effect in an entire category of case, or whether it only has an effect, as in Mathiasson, in their particular case, doesn't matter, we say. And indeed, what is striking from the authorities is that all of the ones, as far as we can sort of say, the main ones cited before you, the remedy was always individual specific. So in the G case, the Northern Ireland adoption case, the remedy was a declaration that the applicants were entitled to apply to adopt a child, of course even though they weren't married. In Brewster, this is MS 542, and you have the declaration, which is at paragraph 68. This was about a requirement for nomination for an unmarried couple. The declaration was that the requirement that the claimant and Mr. McCullen, who was her partner, should have made a nomination, should be disapplied. So again, there's no suggestion of a general finding of ultra vires. And of course, my learned friend is taking you to Mathiasson, where one gets the same outcome. And our submission on the way this can be understood is that it's a form of, and we set this out in our printed case at paragraph 21 of MS 2286, it's a form of what can be described as partial or relative invalidity. That's the phrase used by Wade and Forsyth in their administrative law textbook. And the passage we quote from, or we cite there, is at tab 64 of Authorities Volume 5, 2272. And what they say is they identify a number of cases in which the courts have held, and these are, to answer, I think, a question from Lady Black, it's slightly different. It's not a human rights context, but these were cases involving subordinate legislation, which was held to be valid against certain groups of people, but invalid against others. So they refer to, for example, the Aylesbury mushrooms case, which is about a training order that was made without consulting mushroom growers, and it was held to be generally valid in relation to those who had been consulted, whereas other agricultural groups, but not valid in relation to the mushroom growers who hadn't been consulted. And
I like the sewerage charges better.
And then there's the sewerage, and then there's the sewerage charge case is another similar one, where again the sewerage charge was held to be invalid against those who were not connected to the sewerage system. This is the Damon case, but valid against those that were connected. And that essentially, we say, is how the HRN, and one of the things Wade and Forsyth says, it's not clear how far that principle goes in general public law cases, but it's absolutely clear, we say, the way in which the HRA operates. So you can have legislation which could be invalid as against a certain category of individuals, but because it produces unlawful results, but will remain valid in relation to those that do not fall within that category. And finally, in my last few minutes, I want to deal with a submission made by the Secretary of State, which effectively is what are public authorities then expected to do in these kind of cases. One of the things she says at paragraph 50 of her case is she says, well, this application is only the first stage of the analysis. The gravamen of this appeal concerns whether a new solution can be fashioned by the tribunal or must await legislation. Lord Justice Legate's judgment does not set out the basis upon which this second stage of devising a replacement solution is to be conducted. And what she says is there is no obvious source of answer. Once you say, well, it's disapplied, what do you do next? And our submission, my ladies and my lords, is twofold. First, the solution cannot be for the local authority here to carry on applying the subordinate legislation, because we know that leads to an unlawful result. So there has to be a replacement solution. And secondly, we do say that in this type of case, the replacement solution is in fact obvious, because the way in which this was understood ultimately by the Supreme Court in Carmichael was that it was unlawful because you were treating disabled children who couldn't share a room differently from disabled adults that couldn't share a room. And the obvious solution to that, in fact, the only convention-compatible solution to that, was to treat the adults in the same way as the children. One of the things the Secretary of State says is, well, the legislature has the option of levelling up or levelling down. That may be correct in some discrimination cases. Not clear it is in fact correct in this one. They could have levelled down, taken away the children, the provision for the children, because that's what Burnett held was unlawful. But we accept there will be certain discrimination cases where a legislature can level up or level down. But once you've got the higher provision for the comparator, there is only one way the decision maker can act in a convention compatible way, which is to level up. And finally, a final point made by the Secretary of State is that it said, she's talking about the FTT, but we assume she would make the same submission about the local authorities. She said they're a creature of statute, this is paragraph 40, and they must apply the legislation enacted by the legislature. It said they have no power to calculate housing benefit in any different way. And that's ultimately a vires question, is how does a body such as Sefton in this case have the vires to act in a way that isn't given to it by the subordinate legislation? And we say the answer to that must lie in section 6 of the HRA, because if the consequence of section 6 of the HRA is that a body will be acting unlawful in applying the subordinate legislation, it must follow from that implicitly that they have the vires not to act unlawfully. And that must come from section 6. Now, if there was primary legislation that stopped Sefton calculating housing benefit in a way that was convention compliant, then of course they'd have a defence under section 6. But if they have no such defence, then we say they have to act lawfully and they must have the power to act lawfully. Well, ladies and my lords, that was the Commission's.
Well, thank you very much indeed. That's admirably succinct, and it may be that it gives Mr. Chamberlain enough time to make his submissions.
Ladies, my lords, I'd like to make submissions under 3 heads on behalf of Liberty Child Poverty Action Group and Public Law Project. The first is to answer the question posed in the course of argument by Lady Hale and Lord Reid in relation to vires. The second is to make some submissions about the concept of disapplication. And the third is to make some very brief submissions, mostly in reference to our printed materials in relation to the practical difficulties that would be associated with the Secretary of State's proposed solution to the breach of convention rights in this case, namely a claim for damages under Section 8 of the Human Rights Act. So first, the question posed by Lady Hale and Lord Reid. As to that, we say that there may be cases, indeed there may be many cases, where a breach of Article 14, for example, gives rise to unlawfulness on a number of levels. First, unlawfulness in the making of the regulation, insofar as it discriminates unlawfully. Second, unlawfulness in the application by the local authority or other public decision maker of that regulation to a particular category of individuals. And third, unlawfulness by the tribunal as a public authority in applying the subordinate legislation to someone in that category. Now, we would submit that both types, all three types of unlawfulness are found here. And that's because the subordinate legislation here was made after 2000. In a case where one's dealing with subordinate legislation before 2000, there is an argument, but it's a more difficult argument, which was discussed by my Lord Reid in the T case. That's in Bundle 2, tab 23, at MS 1132, between paragraphs 155 and 157, that Section 3 of the Human Rights Act has the effect of requiring the Parent Act to be interpreted differently after 2000 from the way it would have been interpreted beforehand. But that argument is, we would readily accept, a difficult one, and one that my Lord Reid didn't resolve in the T case. But certainly, so far as we're concerned, the legislation that we're dealing with, the subordinate legislation that we're dealing with here, was made after 2000, and so there would indeed be a vires problem in relation to that legislation under Section 6. But there would also be unlawfulness at the point of applying the legislation, whether by the public authority decision maker or by the tribunal. But the tribunal in this case doesn't need to distinguish in our submission between these two types of unlawfulness, and that's because it is not concerned whether to quash the legislation. That's a power it doesn't have. So far as the tribunal is concerned, the only question is whether the decision in the case before it was lawful or unlawful. And once it's concluded that the decision is unlawful, that is enough for it to allow the appeal. Now, my Lady Black asked the question whether there are any examples of subordinate legislation which have been quashed rather than simply the appeal in the individual case allowed as a result of a breach of convention rights. There are a couple of examples. There's one very recent High Court case, a case called Crown on the Application of TP, 2019 EWHC 1116 QB, in which Mr. Justice Swift quashed the Universal Credit Transitional Provisions SDP Gateway Amendment Regulations 2019 because they contravened Article 14. There's also a discussion which your Ladyships and your Lordship might find useful of this point in the JS case, which was the benefits cap case. Now, in that case, of course, the majority of decision was that the regulations were not incompatible, but my Lady Hale dissented, and there is a discussion in my Lady's judgment, and that's in the Second Authorities Bundle, tab 17, at paragraph 233, of what relief ought to be granted. In fact, the relief that my Lady would have granted had the incompatibility been made out on the majority judgment was not a quashing order, but there was no question that a quashing order could in principle have been granted were it appropriate to do so in the circumstances. So we say in principle a quashing order could follow if one was in front of a court that had power to grant such an order.
In the Unison case, for example, we quashed the fees order, and although the reasoning was based primarily on common law, we said the same result would have followed under the convention.
Yes.
I think Bank Mellet might be another example of a statutory instrument being quashed.
Yes. Indeed so. So it certainly is possible for unlawfulness, and when one's looking at Section 6, one's always got to ask, well, what's the unlawful act? It's always possible for the unlawful act, to be the making by the relevant Secretary of State of the subordinate legislation. But in this case, as I've said, the tribunal doesn't need to concern itself with the question of what form of unlawfulness it's dealing with, because the outcome is the same in either case. And we say that one starts really with three basic propositions. This brings me to my second head of submissions, the nature of disapplication. The first submission is that the most basic function of a judge, or indeed a public decision maker, is to decide the law that is applicable to the case before her, and then to apply that law. The second submission is that in deciding what is the applicable law, the judge or public decision maker has to understand the hierarchy of norms in the legal system. And where a legal rule appears to apply to the case, but on closer inspection actually conflicts with another rule, she's going to have to consider which rule takes precedence in the hierarchy. And to the extent of the inconsistency, the rule that is applicable is the primary rule. And the third proposition is that what the judge or decision maker is doing can, on one level, be characterised as disapplying the subordinate rule. But that isn't some constitutionally unorthodox, newfangled remedy. It's just the flip side, if you like, of applying the primary rule. That's what the judge is doing in that case. And that is the duty, we would say, of every judge at every level, and indeed every public decision maker in a system governed by the rule of law. And that approach is consistent with what you see in Foster. I won't go to it, but just for your note, the reference is Authorities Bundle 1, tab 12, and at MS 630, letter F, you'll see from that case it was common ground that a decision giving effect to secondary legislation, which is ultra vires, is, in the ordinary meaning of the words, erroneous in point of law. The only question in Foster was whether those words, erroneous in point of law, had some more restrictive meaning in the particular statutory context. And the answer given by the House of Lords in that case was no, they didn't. They meant just what anyone would ordinarily understand them to mean. It's consistent with Boddington. Again, I won't go to it, but you have it in the Authorities Bundle 1, tab 8. The issue in that case, of course, was whether the invalidity of a bylaw could be raised before the magistrates as a defence to a prosecution for breach of it, or, as the Crown said, could it only be raised by way of judicial review? And the answer, of course, was that it could be raised by way of defence. And Lord Irvin's judgment in that case looks at the authorities on collateral challenge, Wandsworth and Winder is one of them, and makes the point that is consistent certainly with the approach that absent a contrary indication by Parliament, the duty to determine what law applies to the case before one implies a duty, when two legal rules conflict, to apply the primary one. Or, if you like, to disapply the subordinate one. But they're just two sides of exactly the same thing. And it's also consistent, in my respectful submission, with the approach that the courts take in EU law. Now, Lord Justice Flo, in his judgment for the majority in Carmichael, That's in core volume tab 8 at MS 186, paragraph 57, said that cases which turn on the direct effect of EU law are very different and don't assist. Well, we say with respect that is wrong, because conceptually speaking, a court which disapplies a rule of domestic law because it conflicts with a directly effective EU law right is actually performing precisely the same function as a tribunal or a county court or a magistrate's court, considering whether secondary legislation is ultra vires, as in Foster, Wandsworth and Winder and Boddington. In other words, it's giving effect to the hierarchy of norms in which directly effective EU law takes precedence over domestic law, and applying to the case before it the primary EU rule. An example which you have in the bundle, which I know my Lady Hale and Lord Reid will know about, is the case of Walker and Innospec. And there, a provision of domestic law in the Equality Act, which precluded claims for sexual orientation discrimination in certain pension cases.
I seem to remember you know it quite well, Mr.
Yes,
Chairman.
my lady, I do. Maybe that's why the example occurred to me. But anyway, was found to be incompatible with directly effective EU law. The result was that the domestic law had to be disapplied, but that wasn't the only remedy granted. There was also a remedy granted in the form of a declaration that Mr. Walker's spouse was entitled to a survivor's pension. Why? Because what the court was doing there was applying the primary rule, namely the EU law rule. So the only remaining question then is the question whether the Human Rights Act attenuates that duty to apply the primary rule. And we say the answer is quite the reverse. To answer my Lady Arden's question, this is not a Section 3 case. Section 3, as one can see from the head note to it, is about interpretation.
Well, we're told not to take marginal notes into account in interpretation under standard conventional statutory interpretation. But what meaning do you give to the words "and given effect"?
Well, what I say is the answer to that question is that what Section 3 is doing is it's requiring the court to do something a bit more than we would ordinarily understand by the word interpretation. And that's why the words read and give effect are used. This court and the House of Lords before it have referred to it as a strong interpretative obligation.
But why? Sorry, I interrupted.
But, my lady, I think my answer is that what the draftsman is doing in Section 3 is making clear that the obligation imposed by Section 3 may go beyond what we would ordinarily, in domestic law, understand by the concept of interpretation. But this case has got nothing to do with Section 3 at all. This case is about a totally separate obligation, which is not limited in the way that Section 3 is by the opening words "so far as possible." It's an absolute obligation, and Parliament has very deliberately chosen not to add those limiting words to Section 6.
But it wouldn't have to if Section 3 and Section 3 imposed an independent obligation to give effect to legislation only so far as possible, and Section 6 had to be read harmoniously with it. I just want to put the argument to make sure it's covered.
I do understand the argument. My answer to it, my lady, is that they are two independent obligations. Section 3 is an obligation which applies when one's interpreting primary legislation or subordinate legislation, but it is limited by the opening words. Section 6 is a separate and independent obligation which is not limited by the opening words. It is absolute in its character, but it does not apply, of course, where the incompatibility is either in primary legislation or is mandated by primary legislation. And we say that this chimes with what my Lady Hale said in the case of Re G, which you have in Bundle 2, tab 21, MS 1005, the courts are free simply to disregard subordinate legislation which cannot be interpreted or given effect in a way which is compatible with the Convention rights. And those words given effect are in there because, my lady, as I read that passage, was saying that there may be cases where you can't either read or give effect, at least when that obligation is read subject to the opening words, compatibly, and yet still Section 6 imposes the obligation. Can I very briefly say just a couple of sentences really about the practical difficulties with the solution favoured by the Court of Appeal? We've set these out in some detail in writing in our printed case at paragraphs 35 to 38. Essentially, the points are these. If, on the Secretary of State's case, the only way you can get a remedy for a breach of Convention rights is by bringing a damages claim, that would necessarily involve multiplicity of proceedings. Why? Because you're never going to know in advance whether the tribunal or court is going to say that the incompatibility can be cured by a Section 3 reading down or not. In this case, the first-tier tribunal thought it could be cured by a Section 3 reading down. Mr. Drabble said in his submissions he was at least toying with the idea, although he didn't actually put the submission, that a Section 3 reading might be possible. If one looks back at other cases in which this court and the House of Lords have applied Section 3 readings, it's a very difficult predictive exercise to know when the court is going to accede to a Section 3 reading and when not. So if you were a competent advisor advising a claimant how to litigate their case, you'd have to advise them to go to the tribunal first, seek a Section 3 reading, and then if that didn't work, you'd then have to bring a second set of proceedings. And that itself would not be easy because proceedings in the county court for a very low sum of damages compared to the cost of the proceedings are likely to put up a number of barriers. There are fees in the county court, so one then would have to apply for fee remission, one might have to consider applying for legal aid. Would the case meet the cost-benefit threshold for legal aid? There's the difficulty that welfare advisors are used to dealing with proceedings in the first-tier tribunal, which are inquisitorial, which are informal. They're not used to dealing, as our evidence and the evidence of Ms. Clark from CPAG points out, they're not used to dealing with court proceedings. And then finally, there is a real question about the sufficiency of damages as a remedy. Would the DHPs fall to be deducted in a legally aided case? Would the statutory charge eat up the damages? And finally, when a tribunal allows an appeal, of course, it can determine the amount of benefit going forward. But how does a court assessing damages deal with the fact that there may be an ongoing liability for damages of unknown duration? So for all these reasons, we submit that for reasons of practicality as well as of principle, an action for damages is simply not an adequate alternative remedy. Ladies, Lords, those are my submissions on issue 1. We make no submission on issue 2.
No, it appears not. Thank you very much indeed, Mr. Chamberlain. So we're very grateful to the interveners for having so timed their submissions that we are now back on time. So we will adjourn and look forward to hearing from Sir James at 2 o'clock.